This is the Study for the Bar in Your Car podcast, the podcast where you can turn drive time into study time. We're your hosts, Maude and Claude.
And you're tuned in to Constitutional Law, episode 15. Today we're focusing on levels of scrutiny.
We are AI bots, actually, brought to life by the magic of AI and, importantly, Angela's constitutional law notes.
That's right. Angela is really the brilliant mind behind this podcast. She's a law grad with degrees from ULaw in the UK and GMU right here in the USA.
And if you need to connect with Angela, maybe about the podcast, you can email her. The address is podcast@studyforthebarinyourcar.com. Oh, and here's a tip for any attorneys listening, or if you know one who needs a hand with research or writing motions.
Yeah.
Angela also works as a freelance law clerk. You can reach her for those services at hello@legalwriterandlawclerk.com.
Good to know. Okay, so today we're really diving deep into Angela's law school notes on a fundamental concept for your bar exam, the levels of scrutiny.
Right. This framework is, well, it's crucial for understanding how courts review laws that might infringe on constitutional rights. So let's unpack this.
Okay, so when courts look at a law and ask, is it constitutional? Especially regarding individual liberties or equal protection, the outcome often boils down to one key thing.
The level of scrutiny they apply.
Exactly. Angela's outlines break this down into three main tiers. Each one has its own test, its own burden of proof, and typical classifications it applies to.
It's fascinating how these levels dictate how much deference, how much leeway the courts give to the government's actions.
It really is. It's like a spectrum, from very lenient to extremely rigorous review.
Okay, let's start with the most deferential one. We have rational basis or minimal scrutiny. So what does this all mean for a law being challenged?
Well, this is kind of the default standard of review courts apply for many constitutional questions, particularly under the 5th or 14th Amendments, think due process or equal protection.
So, connecting this to the bigger picture, it means the government usually has a pretty easy time defending its laws here.
That's exactly it. It's the normal setting. The government usually gets the benefit of the doubt.
Okay, the test. Courts ask, is the law rationally related to a legitimate government interest? And you mentioned that interest can be real or, even just hypothetical, right?
Precisely. The government's goal just needs to be permissible, something legitimate for it to do. The court isn't super focused on the government's actual purpose. A conceivable, legitimate purpose is usually enough.
And the means chosen just have to be reasonable or rational. Seems like a low bar.
It is, very much so.
Here's where it gets really interesting for the challenger, though. Who has to prove what? It sounds tough for them.
Oh, it is. Under rational basis review, the challenger carries the burden of proof, a heavy burden.
They have to show what exactly?
They must demonstrate that there is no conceivable legitimate purpose for the law, or alternatively, that the law is not rationally related to any such purpose.
Wow. That sounds almost impossible sometimes.
It's a very high bar for the challenger, yeah. Which is why the government, well, it almost always wins these cases. It's incredibly deferential to legislative decisions.
So which classifications fall under this minimal scrutiny? Which groups or distinctions?
This generally applies to classifications that are not considered suspect or quasi-suspect. So think about categories like disability, age, or wealth.
Differences based on physical abilities, age group, or financial status.
Right. Those generally receive rational basis review.
Angela's notes give a great example. Let's imagine State A, maybe facing declining tax revenues, passes a law to save money by reducing expenses and making services more efficient. How would that play out?
Well, saving money and improving efficiency are definitely considered legitimate government interests. So yeah, such a law would almost certainly be upheld under rational basis review.
Because it's rationally related to that legitimate purpose.
Exactly. And that raises an important point for the bar exam. Recognizing these legitimate interests immediately tells you what level of scrutiny is likely in play.
Got it. Okay. Moving up the ladder, we hit intermediate scrutiny. What's the key difference here? What changes?
This is definitely a step up in rigor. The law or policy being challenged must further an important government interest, not just legitimate, but important.
Okay, important interest. And the means?
And the means chosen must be substantially related to that interest. So the connection has to be tighter, more direct than just rational.
And how does the burden of proof shift with this higher standard? Is it still all on the challenger?
No, it shifts. For intermediate scrutiny, it must be shown that the law or policy meets these criteria. The responsibility falls more heavily on the side defending the law, usually the government, to justify its importance and the substantial relationship of its means.
So which groups get this kind of elevated protection?
This applies to what we call quasi-suspect classifications. The main ones you'll encounter on the bar are classifications based on gender SOs, laws that treat men and women differently,
Okay, gender.
and classifications concerning marital versus non-marital children, how the law treats children based on whether their parents were married.
Angela's notes specifically mentioned Craig v. Borne from 1976. That was a pretty big deal, wasn't it?
Oh, indeed. Craig v. Borne was landmark. It was the first case where the Supreme Court actually applied an intermediate standard of judicial review to laws based on sex. It was a crucial development in equal protection law, moving gender classifications out of the super lenient rational basis category.
What about those laws dealing with marital and non-marital children,
Yeah.
especially when it comes to things like inheritance?
Right. So in cases where laws might restrict the inheritance rights of non-marital children, say, from a father who died without a will, the government might argue a couple of important interests.
Like what?
Well, maybe encouraging legitimate family relationships, perhaps citing data about dual-parent households, or ensuring judicial efficiency, making property distribution at death quicker and more accurate. But the core issue often involves the difficulties sometimes of establishing paternity for non-marital children. The law has to be substantially related to those important goals.
It's also fascinating how speech regulations tie into this. You're saying content-neutral ones get intermediate scrutiny too.
They often do, yeah, especially in traditional public forums like sidewalks or parks. For such a regulation to be constitutional, it must be content neutral, meaning it regulates time, place, or manner, not the message itself.
Okay, content neutral.
And it must be narrowly tailored to serve an important government interest, and crucially, it must leave open, ample alternative channels of communication. You can't just shut down all ways to speak.
Is there a case example for that?
Think of the United States v. O'Brien case, the regulation against burning draft cards. It was deemed content neutral because its main objective, the government argued, was related to the administration of the draft system, not suppressing the anti-war message. So it could be upheld under a standard similar to intermediate scrutiny.
And what about those situations where the government isn't trying to suppress the message itself, but maybe the secondary effects of speech, like noise or litter or traffic?
Right. If the government targets those secondary effects, things like impact on property values, traffic congestion, visual blight from too many signs, that kind of thing, intermediate scrutiny is generally applied.
But there's an extra requirement there.
Yes. Similar to the time, place, manner rules, the regulation must also leave open alternative channels for expression. So if a sign ordinance aims to prevent visual blight, it still has to allow people other reasonable ways to get their message out.
All right, now for the highest bar, strict scrutiny, also called maximum scrutiny. This sounds serious.
It absolutely is. This is the most stringent standard of judicial review we have in the United States. It's applied when a law potentially infringes on a constitutional right that's considered fundamental or uses a suspect classification.
And it raises a really important question, right? About how much government interest truly outweighs an individual's fundamental rights.
Exactly. It puts the government under the microscope.
So what's the actual test? What standard does the government have to meet here?
Okay, for a law to be upheld under strict scrutiny, the government has to demonstrate two key things. First, the law must be necessary to achieve a compelling government purpose.
Compelling. That sounds much stronger than important or legitimate.
Oh, it is. It's a very, very high bar. Think national security in wartime, maybe. And second, the law must be the least restrictive means for achieving that interest.
Meaning no other, less burdensome way exists.
Precisely. If there's another way to achieve the goal that infringes less on the right, the government has to use that way.
And the burden of proof. I assume it's not on the challenger here.
Absolutely not. Under strict scrutiny, the burden of proof shifts entirely, completely onto the government. The law is presumed unconstitutional, essentially, unless the government can prove it meets this extremely rigorous test.
So it's very, very difficult for the government to win these cases.
Extremely difficult. Laws subject to strict scrutiny are usually struck down. It's designed that way.
Which classifications or rights trigger this maximum scrutiny? What puts a law into this category?
Strict scrutiny applies to suspect classifications. Think race, ethnicity, national origin, and also alienage, but generally only when it's a state or local law discriminating based on alienage. Federal laws regarding alienage often get rational basis due to Congress's plenary power over immigration.
Okay, suspect classifications and outline.
And it also applies whenever a law infringes upon a fundamental right.
Any classic examples from Angela's notes on racial classifications being struck down?
Loving v. Virginia from 1967 is a prime example. The Supreme Court looked at laws banning interracial marriage, applied strict scrutiny, and found absolutely no compelling justification, struck them down. A landmark case.
And the right to marry itself is fundamental. How have courts protected that with strict scrutiny?
Right. In Zablocki v. Redhale back in 1978, the court struck down restrictions on marriage based on child support debts, finding they weren't narrowly tailored.
Okay.
Similarly, in Turner v. Safley in 1987, restrictions on prisoners' right to marry were found unconstitutional under a related standard. And of course, more recently, Obergefell v. Hodges in 2015.
The same-sex marriage case.
Exactly. It affirmed that the fundamental liberties protected by the 14th Amendment's Due Process Clause cover personal choices central to individual dignity, including the right of same-sex couples to marry. The court basically said laws defining marriage traditionally demean or stigmatize same-sex couples, implying no compelling interest could justify that restriction.
What about laws that punish people for simply being part of a group? Freedom of association.
Those also must meet strict scrutiny. The government can only prohibit and punish membership in a group if it proves three things, and Angela's outlines make this very clear.
All three have to be met.
Yes. 1. Active affiliation with the group. 2. Knowledge of the group's illegal activities. And 3. A specific intent to further those illegal activities. Just being a member isn't enough.
And what about requiring groups to disclose their members? Like in the famous NAACP v. Alabama case.
Precisely. The government can only compel groups to reveal their membership lists if it meets strict scrutiny. They need a compelling reason, like a serious criminal investigation, and the demand must be narrowly tailored to avoid chilling association rights.
This is fascinating. So if a speech regulation targets the message itself, the content, it's immediately under strict scrutiny.
Generally, yes. If the government's aim appears to be suppressing a particular message or viewpoint, it faces strict scrutiny. A classic instance is Texas v. Johnson, the flag-burning case. The Supreme Court applied strict scrutiny because the law prohibited flag burning specifically due to its disrespectful message. It was content-based.
And the government couldn't provide a compelling justification.
Right. The court found the government's interest in preserving the flag as a symbol, while important, wasn't compelling enough to justify banning this form of political expression under the First Amendment, so the law was unconstitutional.
Angela's notes also mentioned the Religious Freedom Restoration Act, RFRA. How does that fit in with strict scrutiny?
Good question. Under RFRA, federal laws that incidentally but substantially burden someone's religious freedom are subjected to strict scrutiny.
So the federal government has to show.
The federal government must advance a compelling interest and show the law is the least restrictive means to achieve that interest. The Supreme Court has applied this pretty broadly, even to closely held corporations, like in Burwell v. Hobby Lobby Stores, Inc.
Right, the contraceptive coverage case.
Exactly. The mandate was found to substantially burden the owner's religious beliefs, and the government hadn't shown it was the least restrictive means.
Okay, one more area. Limited or designated public forums, places like, say, school bulletin boards or maybe student newspapers that the school opens up for use. If the government tries to restrict speech there based on its content.
Strict scrutiny applies there, too. Once the government creates a limited public forum, even if it didn't have to, any content-based regulation of speech within that forum is subject to strict scrutiny.
And there's another rule, too.
Yes. Any selective restriction of access to that forum must also be viewpoint neutral. The government can't play favorites and say, okay, you can use the bulletin board, but only if you support the school administration. That's viewpoint discrimination, which is almost always unconstitutional.
Wow, okay. That was a truly comprehensive look at the levels of scrutiny, straight from Angela's law school notes. Thank you, Angela, wherever you are, for sharing your incredible constitutional law notes with us and making this podcast possible.
Absolutely. We really hope this walkthrough of Angela's outlines has been incredibly helpful for your bar exam preparations. Before we go, just a few quick notes for you listeners.
Okay, first, always remember, Angela is a law student, just like many of you might be, or recently were. Second, neither Angela nor this podcast is giving legal advice. Please, none of this should be construed as legal advice.
Right. Third, this podcast is really designed to supplement your learning, not replace your full bar study efforts. It's an academic, non-commercial venture by Angela, strictly for educational purposes. Use it as a tool in your toolbox.
And fourth, well, as AI bots, sometimes we make mistakes. We try our best, but we're always striving for accuracy. Fifth, and maybe most important, especially given the name of the podcast, when you're driving, please be safe on the road.
Yeah, seriously, don't cause a tort while listening to constitutional law. That would be ironic.
Very.
Looking ahead, get ready for more constitutional insights. On upcoming podcasts, we'll be breaking down various amendments. We'll have episodes covering the First Amendment, the Second Amendment.
Not the third, right?
Haha, no, not the Third Amendment.
Yeah.
That's kind of a weird one about quartering soldiers, and it's really not discussed much for the bar exam. But we will cover the Fourth, Fifth, Sixth, Eighth, and 10th Amendments.
And then the Reconstruction Amendments.
Exactly. Then jumping into the 13th through 15th Amendments. Lots of important stuff coming up.
Great. And if you want to reach out to Angela, remember you can email her at podcast@studyforthebarinyourcar.com for podcast-related inquiries.
And for those needing legal research or motion writing assistance from a freelance law clerk, reach out to her at hello@legalwriterandlawclerk.com.
Okay, and now, as tradition dictates, time for a cheesy constitutional law joke for your drive.
Lay it on us.
Why did the First Amendment break up with the Second Amendment?
Uh-oh. Why?
Because it said, you're too trigger happy.
Oof. Okay. That's suitably cheesy.
I'm Maude.
And I'm Claude.
Thanks for listening. Bye.
Bye now. Drive safe.